Today, we're going to talk about a strange, but honestly, a really powerful part of the legal system. What happens when you sue someone, and they just go completely radio silent? It feels like you've hit a wall, right? But the law actually has a specific tool for this exact situation, and we're going to break down exactly how you can use it.
Okay, picture this. It's like a high-stakes chess match. You've made your opening move by filing a lawsuit, but your opponent, well, they just don't respond. They don't even show up to the board. Now, in a situation like that, you can't just stand up and declare victory. The rules say you have to follow a very specific procedure to secure that win, and that procedure is called a default judgment.
So here's what we're going to cover. First, we'll nail down what a default judgment actually is. Then we'll get into the crucial first step, something called noting default. After that, we'll look at the two different ways you can get your final judgment. We'll also cover how you prove what you're owed. And finally, how this whole thing can sometimes be reversed.
All right, let's start at square one. What in the world is a default judgment, and why does it even exist in our legal system?
To put it really simply, a default judgment is the court's answer to a defendant who doesn't participate. It's a final, legally binding decision in your favor, basically because the other side didn't show up to tell their side of the story.
And you can see why this has to exist, right? Without it, anyone could just completely halt a lawsuit by sticking their head in the sand and ignoring it. So this rule makes sure there's a real consequence for silence and a clear path forward for the person who filed the suit.
But hold on, you can't just ask for a judgment right away. There's a critical first step you have to take, and it's called noting default. This is how you make the defendant's silence official in the eyes of the court. Let's see what Rule 19.01 says about this.
The process is super methodical. You have to follow it to the letter. First, you've got to prove to the court that the defendant actually got the lawsuit papers. That's called filing proof of service. Second, you have to be patient and wait for the deadline for them to respond to pass. Once that clock runs out and you've still heard nothing, then you can go to the court registrar and ask them to formally note the defendant in default.
And this is where things get really serious. This is way more than just a piece of paperwork. According to Rule 19.02, once a defendant is noted in default, the law considers them to have admitted that every single fact you allege in your claim is true. They're also totally locked out of the case. They can't file a defense or do anything else unless they get special permission from a judge. This gives you a massive, massive advantage.
Okay, so the defendant is officially noted in default. Now you've reached a fork in the road. You still need to get that final judgment, but how you get there depends completely on the kind of claim you made. There are two very different paths you can take.
Path number one is quick, it's administrative. You can just go to the court registrar, that's an official who handles the court's paperwork, and have your judgment signed. This is for the simple, straightforward cases. Path number two is more involved. It requires a formal court hearing in front of a judge, which is called a motion. You'll have to take this route for more complex claims, where a judge actually needs to assess the situation.
So, how do you know which path to take? Well, Rule 19.04 spells it out. If you're suing for a specific fixed amount of money, the law calls this a liquidated demand, or you want specific property back, the registrar can handle it. Easy. But if you're claiming damages that need to be figured out, like compensation for pain and suffering, Rule 19.05 says you have to go see a judge.
So let's zoom in on that second path, the one that leads to a judge. This is the most common route when the money you're owed isn't just a number on an invoice. In this case, you have to actually prove your damages to the court.
The big difference here is liquidated versus unliquidated damages. Liquidated is easy, right? An unpaid invoice for $5,000 is, well, $5,000. But unliquidated damages are different. They're not a fixed sum. The court needs evidence to figure out the right number, like trying to calculate compensation for an injury after an accident.
And this is where the rulebook gets super specific. Rule 19.05 is crystal clear. If your claim is for these unliquidated damages, your motion has to be supported by evidence. And that evidence has to be in a very specific format, a sworn written statement called an affidavit.
Think of your affidavit as your entire case on paper. It's your one shot, it has to tell the whole story, it has to present all your proof, like repair estimates or medical reports, and, crucially, it has to show your math. You have to walk the judge step by step through how you calculated the exact amount of money you're asking for.
Now, this is a really important check in the system. Rule 19.06 makes it clear that even though the defendant is considered to have admitted all your facts are true, that's not an automatic win. Those facts still have to legally justify the judgment you want. So for instance, if the story you tell doesn't actually describe something illegal, the judge won't give you a judgment, no matter what the defendant did or didn't do. Your case has to be solid on its own legal merit.
So you did it. You followed all the rules, you got your judgment, case closed, you won, right? Well, not always. The silent defendant can sometimes wake up and decide to challenge the whole thing. You know, the system recognizes that life happens. Maybe the defendant was in the hospital, or maybe they were never actually served with the lawsuit in the first place. The law has a built-in mechanism to potentially undo a default judgment if there's a really good reason.
Under Rule 19.08, a defendant can file their own motion, asking the judge to set aside the judgment. The judge has the power to do this on such terms as are just, which usually means making the defendant pay for all the time and money you wasted. If the judge agrees, they can basically hit the rewind button, wiping out the judgment and even the original noting of default, giving the defendant a second chance to actually fight the case.
Okay, so let's boil this all down. What are the key takeaways? First, default judgment is the essential tool that stops cases from stalling out because of an unresponsive defendant. Second, that first step, noting in default, is huge, and it has serious consequences. Third, your path to judgment is administrative for simple claims but goes through a judge for more complex ones. Fourth, if you're proving damages, a rock-solid affidavit is absolutely essential. And finally, always remember that even a successful default judgment isn't set in stone. It can be challenged and even reversed.
So, we've just walked through the how of this whole process. You know the mechanics. But understanding the rules is one thing. Playing the game is something else entirely. Knowing when to push for that default judgment versus when it might be smarter to give a defendant a little more time, well, that's not just procedure, that's strategy. And it can make all the difference.